So we've gotten to the part of your case when you are about to begin discovery. Discovery is the largest time that you will spend where there is some activity that's needed by the plaintiff and the defendant to get work done in the case. We don't try cases in the US generally without discovery. And discovery is the process of gathering information to let each side know the strengths and weaknesses of the other side's case so that they can make a better decision about whether the case should go forward, whether there are weaknesses in the case that should make it be dismissed, or whether there's a likelihood that this case will have to go to trial and a jury or a judge will have to resolve it. So as we go through, it is not enough for a litigant to simply file a complaint in court and then you get a trial. That is not how it works in our society. Once you file a lawsuit, the other side will file an answer, and the answer and the complaint, once those two things are filed, there will be a time when each side exchanges information. There's certain information that we get from the other side, and there's certain information that we give to the other side. Each side has a duty to respond to that. That means that if you're the plaintiff, that you're going to have to provide information. Some of that information will be in the form of written answers, where the other side sends you questions, and those questions can ask you things about your background, where you went to school, have you had criminal convictions, what is your work history, what happened, the actual facts of the case, ask you about certain information that they have questions about based on the complaint. Those answers have to be given and signed. You, as the plaintiff, has to sign those. Those are called interrogatories, and those are written questions to the other side. Each side can send interrogatories to the other. There are also what's called requests for production. Those are documents that you may have kept or have the ability to get because you are the owner of those documents or you have an interest in those documents. The other side will send a list of things that they would like to get from you. Some of those things might include records that you have from the other side. They might be records that you've gotten from other parties. There might be non-parties. So maybe you got a document from some witness, or maybe you have evidence in your medical records that they want. They will send you requests for production, and you will have to provide the other side with those documents so that they can review them and figure out how they fit into the case. Now, some of the questions that they may ask and some of the documents that they may request may not seem relevant to you. Those are questions that the lawyers will hash out. So your job as the litigant, the person who is suing, is to provide the documents to your lawyer so the lawyer can review and determine which ones need to be turned over. You should give your lawyer everything. Tell your lawyer the right answer, the full answer, provide every document that could possibly be relevant to your case. If you don't provide those documents and you later want to use them against the other side, you will not be allowed to use them. So the best practice is to be more inclusive and let the lawyer decide whether those documents need to be produced to the other side, whether they respond to a particular question. Okay, so make sure that you're providing that. The other thing that the other side can ask you to do is to provide answers to requests for admissions. Admissions are a specific type of question that really call for you to admit or deny. So yes or no answer, either this is true or it's not, to a certain statement. So it might say, admit that your birthday is February 23rd, and you can admit. And if your birthday is February 24th, then you would deny. It might say, admit that you live at X day, at X address. And that would be you would admit or deny those. There are specific questions that usually are able to be answered very succinctly, and you can send that out. And the fourth and most important part of discovery for the litigant is the deposition. And the deposition is a place we'll sit down in front of a court reporter and answer the questions that the other side has. They'll be taken down, they'll make a record of it, you'll be under oath, and that information will be used for you later on. Now, we'll have some other videos about what a deposition is and what you'll do with it, but this is one where you have to be very careful, and you have to answer your questions, and you will be required to sit for a deposition. If you are not prepared to sit for a deposition, then your case will probably not be able to be brought to the highest value that it can. You have to sit for your deposition. Now, there are some other tools that we can use for in discovery that the lawyers use back and forth, and typically those are subpoenas, and subpoenas go back to non-parties. So if I need to get records from, let's say, a company that you did business with, or that the company that we're suing did business with, I send them a subpoena and they respond to me. Usually, the people who are parties to the litigation don't send subpoenas to each other. In fact, that's not how we normally do it. And when we're in federal court, we do what's called initial disclosures. Initial disclosures are when we take the documents that you have given us that we think are definitely relevant to this case, and we send them without them asking for them to the other side. Those are documents we think are important. And we do those at the very beginning, and that's done to make sure that the rest of the litigation goes very smoothly and that we don't waste time having to ask for things that we always need to get. And there's certain categories of documents that we know we're going to have to give. We will probably have to give you some pay documents. We will probably have to give medical records that are relevant to your case. And so it's just easier, if we know that these things exist, to send them on the front end so that we don't have to scramble to get those. And the reason why we're going to do that is, one, it makes it easier. If we know more about our cases, we know what the strengths and weaknesses of our cases are, we can evaluate them and we can get them done quicker. So if you hold back or you don't give us all the information, it's going to slow your case down. So if you give us all the information on the front end, we can make a quick evaluation about what your case is worth and whether or not you need to proceed with it or not. So that's sort of the overview of discovery. Once discovery is over, the next major step is dispositive motions. And those are motions that one or both sides can file to have a case either dismissed or ruled and have some issue ruled on by the judge, so that only a certain part of it or no part of it goes to the jury. But the biggest thing that the litigant, the plaintiff or the defendant, has to be involved in is the discovery part. And once that discovery part is done, that is the most important milestone in your case. So if you have any questions about discovery or what we need from you in discovery, just make sure you send us an email at fontenot@fivepointslaw.com.